Hi, I'm Mario Correa, and I recently had a client come in, and they had an issue, and it was really a sad one, and it has to do with estate planning versus ownership documents. So let me kind of explain what that means. Well, there was a client that what happened was his mother had married somebody, and and they bought a house together, and the mother wanted her share to go to her son. And it was obviously of a child of a first marriage, not the second marriage. So what she does is she goes to an attorney's office, and she was trying to save a little bit of money and does a simple will. And the will says, I give the house to my son, and then the balance of the assets can be split between my son and my new husband. The problem is that the ownership document, in this case the deed for the house, was in joint tenancy. What that means is that when the mom died, it didn't matter what the will said, because in all estate planning, it's the ownership document that controls before the will or the trust. The ownership document for a parcel of real estate is a deed. That's who shows us who the owner is. And that took priority. By being in joint tenancy, it transferred automatically by operation of law to the second husband, and the child lost their inheritance. He was actually kicked out of his house, and it was actually quite a sad story. So always be sure to make sure that you don't have these unintended consequences happen to you by having your ownership documents list things the proper way. The ownership document should either list the trust as the beneficiary, the ownership document should, or name the trust as the actual owner, and that's how you can properly use a trust. If you have any more questions, you can call me, Mario Correa, at 773-489-8500.